My name is Angela Chang, and I am the Chief Strategy Officer at KCAL Insurance Agency. My dad started the insurance agency in 1992. What started off as one man's dream is now an office of over 140 people in Southern California. At KCAL, being a part of our community is super important to us. So we take part in a lot of community events. And I am the Chief Strategy Officer at KCAL Insurance Agency. My dad started the insurance agency in 1992. We position our agency to really be a partner to all of our clients. An office KCAL Insurance Agency will always be there for you. At KCAL, being a part of our community is super important to us. So we take part in a lot of community events. And I am the Chief Strategy Officer.
Thank you for taking the time to join our webinar, What the Rental Housing Industry Needs to Know. My name is Angela Chang, and I am the Chief Strategy Officer at KCAL Insurance Agency. COVID-19 has impacted all industries, and the housing market is no exception. Rental housing professionals are facing many challenges in the industry and are beginning to have questions about what actions they can take. On this webinar today, we will cover a wide range of topics, including regulations around the eviction moratorium and rental assistance, how you could take advantage of current mortgage relief programs, and how to protect yourself from fraud that's been targeting California homeowners. Coincidentally enough, I'm in the process of moving apartments myself today. That being said, I'd like to introduce everyone to our esteemed guest, Attorney Paul Chang. Paul's the managing partner of the law offices of Paul P. Chang and Associates. He has extensive legal experience in small to large business operations and commercial realty transactions. He's counseled individuals and businesses at all levels in a variety of transactional and litigation matters. Paul was a deputy city attorney, city prosecutor, and mediator with the city of Hesperia, California, prior to entering private practice. And he was recently elected to the Arcadia City Council, District 4. He also served as the immediate past president of the San Gabriel Chamber of Commerce. Without further ado, I'd like to introduce you to my mentor and friend, Attorney Paul Chang.
All right, well, thank you, Angela, for the very sweet introduction. I wanted to make sure very quick, because I'm getting a little bit of feedback on my end. Are you able to hear me consistently? Is there some static or anything going on? Are you okay?
I can hear you. The feedback just stopped for me as well.
Okay, great. Okay, all right, cool. So I'm going to share my slide and let's see. Are you able to see my PowerPoint?
Yes, indeed.
Okay. Well, I wanted to thank each and every one of you for coming today. I'm very excited for you. KCAL Insurance is the only insurance company in Southern California that I know of that really gives back to the community, giving back to the community in terms of lectures, in terms of really wanting to make sure that Southern Californians are really prepped on the law. And so I'm very excited today because KCAL Insurance, as well as our law office, we're going to be giving a lecture in regard to evictions and law of California. And I apologize, we had a very late night. As Angela said, I'm the city councilman of the city of Arcadia. Very, very worried, obviously, about the fire, this gender reveal party that ended up being this fire in the San Gabriel Mountains. And so a lot of the elected officials are very worried about our cities. But fortunately, as of today, the wind was blowing north away from much of the cities. So we were able to have somewhat of a night's sleep, but at the same time, I think the PowerPoint may have some typos. I apologize for that. Just a quick disclaimer. This is for general educational purposes only. And what does that mean? It means that I am not your attorney. KCAL Insurance is not your attorney as well, providing legal advice. And if you want to get legal advice, you need to go to a law firm. And KCAL Insurance is nice enough to present this lecture for everybody to understand COVID. So we only have 1 hour. Is it enough? Not really, but we're going to try to get as much information as we can in. Here's the breakdown of the lecture. You need to understand COVID law, but you actually have to understand pre-COVID law, meaning that you have to understand the general process of evictions. And we're going to be going into that so you can be able to understand how evictions work in general. The next issue is we're going to talk about what's happened as of September 3rd, really September 1st, but the law really landed on September 1st. All these analysis came out, and really, September 3rd and on, the hot and fresh law. And then you need to learn a little bit of the background of COVID law. So we're going to go back a little bit. And then what we'll do is we'll talk about if you're a landlord or you're a tenant, and we're going to answer some general questions that you may have. So what I've done is I've broken down over several slides, I've broken down the flow chart for an unlawful detainer. So for those of you, and I get a lot of attorneys that want to hear this lecture as well, attorneys welcome. For those of you that are unfamiliar with how evictions work, over the next few slides, I've put together the way an eviction would work. So for example, let's start here. Tenant doesn't pay rent. Property owner or manager serves a 3-day notice to pay or quit, or other such notice, such as a 30 or 60-day notice, according to the civil or civil procedure code. Tenant moves out or pays if payment and option on notice. Tenant doesn't move out. So I basically give you kind of step by step. And then it goes down from here. Then the tenant is served with the summons and complaint. And then here, tenant moves out or pays all rental fees. Plaintiff files a request for dismissal. If it does not, then the tenant files an answer here. Or if there's no answer, then there's a default. So what I'm trying to say is that I've mapped out the entire eviction process for you. That's what I'm trying to say, all right? And so for those of you that don't understand it, or for example, right now I feel a little bit tongue-tied, that people may not understand what I'm saying, it's on the PowerPoint here. And the great thing about KCAL Insurance is they've asked me to ensure that the PowerPoint is available for people that want it. So if you're interested in the PowerPoint, just contact KCAL Insurance, or you can contact our law office, and we'll provide it over to you. Next slide. Once you obtain judgment, the tenant either moves out, or if the tenant doesn't move out, then you get a writ of execution, sheriff, and final eviction. So a quick summary of how an eviction works typically is you have a landlord-tenant relationship between a tenant and a landlord. The tenant breaches some part of the agreement, and usually it's not paying rent. So today's lecture is really about not paying rent. And so when you don't pay rent, what ends up happening is that the landlord needs to serve on you a 3-day notice. This is pre-COVID. It needs to tell you this is how much is owed, and if you pay within 3 days, then the landlord cannot evict you. If you do not pay in 3 days, then the landlord needs to serve on you a lawsuit. And then obviously you can fight about the lawsuit, or you can just not answer the lawsuit, and then there'll be a default. Then there's a process between the service of the lawsuit and final eviction. And there's a middle process in the middle called discovery, and we'll go over that issue. And then once you get a judgment, you obtain a judgment, it is not enough. The landlord, if the tenant refuses to move out, still must get what's called a writ of execution from the court. And then the sheriff will actually go out to serve the tenant and force the tenant to leave. That's how you evict. Now, why am I emphasizing the word sheriff? Because whether it's pre-COVID or whether it's after COVID, no matter what happens, you cannot evict a tenant unless the sheriff goes out and evicts them for you. So I'm going to repeat that again. You cannot evict a tenant physically remove a tenant unless the sheriff does it for you. Even if you go to court and you get a judgment, you still cannot remove the tenant physically. You must get an additional document called a writ of execution, and then the writ of execution you will bring to the sheriff's department, and then the sheriff will go over to the tenant, give them notice of the writ of execution, give them typically 3 to 5 hours, and then once the tenant leaves, or if they don't leave, they're physically removed them from the premises, that is when you can change the locks on the door, and that is considered final eviction. So very quickly, no self-help. What does that mean? We've just repeated it earlier. You cannot physically remove a tenant. You are not allowed to do so. The court is not allowed to do so. The only person that can be able to enter into a premises based on eviction is the sheriff. Once the sheriff does it and they give you permission based upon a writ of possession, that is the only way you can be able to go in. The reason why this is very important is because there are a lot of landlords right now, they're getting very frustrated. I had a landlord hire a bunch of security guards, knock on their tenants' doors and tell them to pay rent or they were going to be evicted. That is illegal. You cannot do that. You cannot use self-help. Self-help comes in many ways. Turning off the lights, turning off the electricity, shutting off the water, banging on the door. Those are all considered self-help. All of them are illegal. Changing the locks. You know, many times, people that are from foreign countries, they believe that the law in their country is the same law as in America, and it may make sense over there. There are many countries, for example, in Asia and South America. If someone doesn't pay rent, then the landlord can come in, change the locks. That's very reasonable. Sounds like it makes a lot of sense, but not here in California. It does not work that way. So no self-help. These are other reasons why a termination can occur. I'm just kind of listing it for you. Expiration of a fixed term, tenant's death or incapacity, mutual consent, illegal use of premises. These are just some examples. That's all. Common commercial reasons. You know, there's a breach of other covenant in the rental agreement. For example, let's say that the landlord leases to a restaurant and the restaurant releases to a portion of the restaurant, releases to a cigar shop, right? There's still a landlord-tenant relationship, but the agreement may say you cannot assign or sublease your premises. So that's another reason. Commercial 3-day notice, I'll skip this just because it is very relevant. Very relevant, meaning that a 3-day notice is not always required for commercial tenancy. However, a residential tenancy, you always have to give 3-day notice. However, for commercial properties, attorneys always recommend, even if your agreement states that you don't have to give a 3-day notice, you still give a 3-day notice. Service of a 3-day notice does not mean that you waive any and all rights. You still have to comply with the rest of your agreement. That's just a very quick slide on that. Service of the notice itself does not restore the landlord to actual possession. So you still need to have the court to be able to help you, and eventually a sheriff. And I believe this is a typo here, so we may need to correct this later on. I'm actually speaking to another attorney right now. It's next to me. So this is very important. When you evict a tenant and it is for a residential property, you can only get rent that is due if on your 3-day notice on a residential tenancy, you state more than the rent that is due. It is ineffective and you will lose your lawsuit. So there's an example that I provided to you. There's a $5.96 overstatement in a $1,078 3-day notice, and therefore it was deemed ineffective. All right. There's another court that talked about an $18 overstatement, and that was okay. However, this case is the one that controls $5.96 overstatement. So please be careful. Please be careful. In commercial tenancies, you don't have to have precise amount of rent. You can have an estimated rent due, but it must be reasonable. So residential tenancies, it must be the exact amount that's due. Commercial tenancies, you can have an estimated amount that's due, but it must be reasonable. And again, we're trying to get through pre-COVID law as quickly as we can. So please be patient. We're getting there, all right? So this is just the 1161.1. 3-day notice of commercial tenancy can be an estimate so long as the amount is reasonably estimated and clearly identified. So people always ask me, well, in the agreement, it talks about rent. And then it says, if you're late, I get to add penalties to the rent, and it's all rent. Is that okay? The answer is, it's not okay. If you have rent that's due, and you have things that are not rent, please do not put it in your 3-day notice. You know, the funny thing is this, obviously you guys know, I do 3 areas of law, and these areas of law have become so huge during COVID, right? So although we have other attorneys here, I do business, real estate, and labor compliance. Those are my 3 big areas. And I can be able to tell you that every once in a while, just for kicks, I'll take on a tenant case, and I've never lost a tenant case. And there's a reason why behind that, because typically tenants always lose. Well, one of the ways that I'm able to knock out a lawsuit is I always notice that landlords and attorneys always have in their 3-day notice an overestimation. The amount is not precisely identified. You would rather get less money on a judgment and be able to evict than put every penalty, trash, utilities, everything in, attorney fees, all of that into your 3-day notice. So it's just one of my secrets, not really a secret, but these are one of the ways I'm able to win. Very quickly, you can also give a 1161. This is alternative to a 3-day notice. It doesn't supersede 1161.2. So just very quickly, common error, estimated rent, just be very careful about it. If it's for commercial, please let it be reasonable. One way is to do a no amount stated. So this is one way that you can be able to get around. You don't have to necessarily go after a precise or estimated amount. However, I do want to say this. There's a difference between not going after rent and suing in civil court and failing to state an amount that's due. So be very careful about that, and you can be able to read this slide on that. This is just a sample of how a 3-day notice looks for commercial tenancies, but it's also very similar for residential tenancies as well. Okay, so just providing you a sample. Again, this is another slide that just talks about rent only. That's it, okay? This is another slide talking about rent only. Triple net for commercial leases. Just want to be very careful that your agreement many times are very unclear if it's a commercial tenancy in terms of what triple net is. And for those of you that are commercial tenants or commercial landlords, you'll know exactly what I'm talking about. This basically says that you need to have your 3-day notice be very clear. That's all. And the 3-day notice needs to be extremely clear, or I would recommend to the landlord serving a second 3-day notice. This is pre-COVID. I just want you to know the law is now changed for COVID. It must be a 15-day notice. It is true, but you need to understand pre-COVID evictions to know how to do COVID evictions correctly. Again, a tenant is able to cure the rent default by paying the amount due within 3 days. I do want you to know that some landlords, what they do is they give you a 3-day notice and they make themselves unavailable to receive the money because they want to evict you. what you need to do as a tenant is you need to go to your bank, you need to open up a bank account very quickly, you need to deposit that money into a separate bank account and use that as a defense when you go, if you're being evicted. Basically to be able to tell the court, I had the money, they were unwilling to take the money, and therefore I've had the money here. That's another way why I've been able to win defense cases. Again, not a secret, but just how I've been able to win. This is the slide for refusing rent, okay? So a landlord cannot refuse rent. Another way is that landlords can be able to evict tenants based upon non-rent issues. So it's a breach of covenant other than payment of rent. And in fact, my position, and I believe most attorneys take the position as well, is the new law that's coming down, that has come down, it only relates to rent only, meaning that if you breach for another reason, landlords are able to evict you based upon other reasons not related to rent. So be very careful, because I think what many tenants are doing is that tenants are taking the position, well, you know what, particularly, the residential tenants. For the commercial tenants, they only have until September 30th. Residential tenants, they have until next year. But what they're basically doing is, I'm not paying my rent. I'm not doing anything under the lease, nothing under the lease. And I can be able to tell you that landlords, in my opinion, they've been speaking to me as well as other attorneys. I think we're all taking the position from a landlord standpoint that we can be able to evict you. That's not going to be an issue if it's a non-rent related reason. Okay, these are just things that we've talked about before. But you see, these are non-curable issues. See, if the issue can be cured, you need to have a 3-day notice that says you need to perform this issue or you can quit, right? So there's a 3-day notice to pay or quit, but when it's a non-rent issue, it's a 3-day notice to perform a specific action on the agreement that you can't cure it. The cure means fix. So for example, one of the issues is a sign or sublease. If you've assigned it to somebody else or subleased it to somebody else, there's no way to cure it, all right? And again, these are other ways to terminate leases. So here's a sample notice that I'm providing over to you for nuisance, just so you can see it. This is very important. Most attorneys, most attorneys that work for landlords in terms of evictions do things in a very cheap way. The market is very competitive. Attorneys like myself, we do things hourly. So I'm $600 an hour. But there's a reason why attorneys are able to do it very inexpensively. And I want to tell you that I don't recommend it. And very rarely do I say that. If you've been part of my other lectures, I give you a lot of information. I tell you, you don't need an attorney for a specific area. But if you really want to be successful, both evicting a tenant or opposing or defending a lawsuit, you need to do what's called discovery. So discovery in the United States is the pre-trial phase in a lawsuit in which each party can obtain evidence from the other side. So you're able to ask them questions. If you're a tenant, you're able to say, tell me how I breached the lease. Tell me how much money I owe. You're able even to make them say yes or no. Admit that I didn't breach the agreement. Right? You can ask them questions like that. And the attorneys essentially have to respond. Now, why do I recommend that you do discovery? And why am I so successful in defending tenants as well as evicting tenants? Is because of the fact that in a regular lawsuit, so evictions in California, they are in a special court, all right? So it's like family law, they're in a special court. They're not in a regular court, they're in a special court. Evictions, they're also in a special court as well. However, in California, because you have this thing called discovery, people ask questions back and forth, depositions, things like that. there's one special thing about eviction court that's very different from a regular lawsuit. You only have 5 days to respond, 5 days to respond. So one of the things that I do is, as soon as my client gets served with a lawsuit, I serve the other side discovery. For example, if I'm on defense, and I say, admit that I did not breach the agreement. The attorney on plaintiff's side doesn't respond. They think I'm being stupid, right? They think, oh, well, this is an eviction. It's very cheap. I charge the client $750 or $1,000, $1,500. And I'm able to just pummel the other side. Same thing. When I'm on plaintiff's side, I also ask the other side, the tenant, I say, admit that you breached the agreement. The tenant typically doesn't respond. The reason why this is important is because evictions, the timeline is so short, it's only 5 days to respond, that if the other side doesn't respond in 5 days, I'm able to run into court. I'm able to tell the court the other side does not want to participate in the lawsuit, and the court must agree that my position is correct. So the reason why I'm able to win many tenant side cases is because the other side typically doesn't respond. I basically go in and I knock them out, particularly on request for admission. Request for admission. So just want you to remember that. Full discovery is permitted in all unlawful detainer proceedings. A lot of attorneys don't know this. The response time is 5 days. Typically, parties do not respond. And that's the reason why I win. All right. And this is the request for admissions. Okay. All right. We're in it now, guys. COVID time. All right. So now we get to learn about what is going on. What is going on as of September 1st? All these new laws coming down. Now, I do want to warn you that although it came down September 1st and 9 days later, if you go online, you're going to get 20 different answers. And unfortunately, I'm one of the 20 different answers on what has actually happened. I believe it's going to be about another 2 to 3 weeks before the guesstimation becomes something more firm. So I do want to warn everybody that you do need to read yourself the statute. So this is a website that you need to commit to memory or just have it in. It is a website that has all 50 states evictions law, and it has all of the counties as well. So this is what I use and what I recommend attorneys to use, because a lot of attorneys come to us because they don't practice landlord tenant or real estate law. I tell them to go to this specific link, and it gives you a great summary. So I'm you guys again. This specific link that I'm providing is a link that very few people know about. And I want you to commit it to memory and to have it ready for you, because it has all 50 states, eviction law related to COVID available for you 24 hours a day, and it's updated on a daily basis, okay? All right. So Trump passed a law on September 1st, 2020. And a lot of people aren't talking about it because they're so worried about AB 3088. And I want to tell you that I believe both laws you have to be familiar with. So let's talk about the federal law first. President Trump passed a law hours after California passed its own law. And here are the requirements. It's effective until December 31st, 2020. There are people that are not qualified, and those are people that could not qualify under the CARES program. I don't know if you remember, but there was a period of time everybody was talking about, oh my gosh, the government's going to give to us $1,200. How do I get the $1,200? Well, the law was this. If you make more than $99,000 individually or $198,000 as a couple per year, you did not qualify under the CARES Act. So if you make more than that, don't worry about the Trump law. If you make less than that, you were qualified under the CARES Act, and therefore this law applies to you. You need to have a declaration. You need to swear that you would become homeless or force you into a shared living setting. You need to say that you use your best efforts to obtain government assistance. And the best efforts is in quotes. You must be experiencing a substantial loss of household income, a layoff, or extraordinary out-of-pocket medical expenses. These are all very important. You must attempt to make partial payments. So you need to do your best to make partial payments. Now, what does that mean until the end of the year? It means you can't be evicted. But there's an ambiguity. The ambiguity says that the moratorium will defer to states with more generous protections. However, the California moratorium that we're going to discuss next, although it gives you more time, it has more requirements. Which one controls? So in my opinion, what I've been telling landlords and tenants is that if you don't qualify, you have to look at both, right? You can't just say, I don't qualify under 3088, or I don't qualify under the Trump new law, and therefore I don't qualify under the other one. I think both of the laws control, because although the Trump moratorium says that if your state, which is California, has more generous protections, that one's going to control. Some people would argue that the California is not necessarily more generous because it does have more requirements, if that makes sense. All right. Where do you find the form for the declaration? You just click on this link. That's it. A sample document is attached. If you want to know whether you qualify for this Trump moratorium, the CDC has provided an eviction moratorium assistance to see if you qualify. So you just click on this link and you just basically, they just ask you, I think 4 to 5 questions. I actually did it to see how easy it was. It is interesting that it's provided by the CDC, but it is what it is, okay? Now, let's get to the AB 3088. I know a lot of you are here because of the fact that you want to learn about AB 3088. For those of you that came in earlier, I wanted to just recap really quick what we learned. We learned several things. First, we learned about generally evictions pre-COVID. And then the main issues that we learned in the pre-COVID era is, one, you cannot use self-help. You can't lock anybody out. That has not changed. That has not changed. The second issue is that if you're going to litigate a eviction case, I definitely recommend doing discovery, because we're able to win many lawsuits both on landlord and tenant side using discovery. And then now we've just finished the Trump moratorium, and now we're going into AB 3088, which is a majority of the reason why you are here. So hours before the Trump moratorium was passed, California enacted its own moratorium. It was signed by the governor and goes into effect immediately. So right now, AB 3088, it is in. There are 5 basic components of AB 3088. We're going to discuss most of them, not all of them. It provides new protections for non-payment of rent. There's an extension of just cause evictions through January 2021. It expands the small claims jurisdiction for COVID-19 debts. It limits your local eviction moratoria, and there are new penalties for illegal lockouts. So let's talk about it. For those of you that want to actually see the law, it is very important, both if you're a landlord or a tenant, for you to actually read the law itself. It is very long, but you still have to read it. It expires on February 1st, 2021. This is for the portion of rent that is due, and I'm going to explain that. It does not, in my opinion, protect landlords from foreclosures or force banks to give you mortgage forbearance. However, if you are a landlord and it is under a government loan, the government may actually give you an extension of time to pay your mortgage. So it is very important that you find out from your bank, if you're a landlord, whether you have a government-owned loan or not. So Fannie Mae and Freddie Mac, very quickly, you've heard of those terms, property. Many times the government buys the loan from the person that loaned you money. And the government now is almost like the bank. The reason why they do that is so that way they give money back to the person that loaned you money, and then the person can continue to reloan money. So it creates liquidity. Although AB 3088 does not specifically prevent foreclosures on your property, there is a benefit for mortgages that are government owned. So if you have a mortgage that's government owned, please find out right away. You may be able to get a deferral of the mortgage. AB 3088 is considered a compromise. There was another law that was more extreme. It was AB 1436. It would have protected renters from the beginning of unpaid rent all the way to April 1st, 2021. And there were other laws that were going on. Some laws that they were considering said that you never had to pay at all. And so AB 3088 is considered a compromise between many of the elected officials that are both in both houses up in California. AB 3088 does not apply to commercial tenancies. I will repeat that. AB 3088 only applies to residential tenancies. There is currently AB 3088, there's currently a county moratorium for both residential and commercial, but obviously the residential part doesn't matter because you have AB 3088, but the commercial one goes all the way until the end of this month. And so at the end of this month, the landlords that are going against the commercial properties, unless there's another extension, we are going to be able to evict commercial tenants. So just something to think about. The 3-day notice earlier that we were talking about, it was very critical. The 3-day notice got to be perfect. You can't overstate rent. It's now 15 days. So before it was 3 days, now it's 15 days, right? If the rent or other charges due is between March 1st and January 31st, 2021. So this is very important. March 1st to January 31st. Just FYI, in terms of residential rent that's due, you only have 1 year to be able to collect that rent from a lawsuit standpoint. So I do want to just warn people about that. But in your mind, if you're going to evict somebody and it's based upon the COVID time period, it's now 15 days. 15 days. If during the 15 days when you serve a tenant, they return a declaration under penalty of perjury of financial distress, if it's from March 2020 to August 2020, the landlord cannot evict. The landlord cannot evict. From September 2020 till January 2020, the landlord must allow the resident until January 31, 2021 to make a 25% payment that's owed, and can only evict the tenant as of February 1st if the resident fails to make that payment as of January 31st, 2021. It's 25% of rent that is owed. Now, there's some ambiguity whether it's rent plus other charges or if it's just rent. So again, in my opinion, humble opinion, your 15-day notice is just for rent only. just for rent only. I know it seems unfair, but it is what it is. State law provides eviction protections through January 31st, 2025. But in order to be protected, you must return the declaration of financial distress within 15 days after receiving an eviction notice and pay 25% of all rent owed from September 1st, 2020 through January 31st, 2021 by January 31st, 2021. That's just the summary. Now, this is what tenants are going to do if you're a landlord. You're going to serve the 15-day notice, and many tenants, I would say 80% of the tenants, they're going to ignore you. Why are they going to ignore you? Because they went online or they went onto a government website and the government says, we are so great. We have passed AB 3088. You can now get rent deferral until next year. Well, the problem is they're not very clear about the declaration of financial distress under penalty of perjury. It needs to be returned within 15 days. If you do not do that, you are technically in breach. And in my opinion, can be evicted. Here is the declaration of COVID-19 related financial distress. This is an example. I am currently unable to pay my rent or other financial obligations under the lease in full because of one or more of the following. These are just some of the examples that I give as a declaration that you could provide or a tenant would provide to you. I've lost income caused by COVID-19. I have increased out-of-pocket expenses directly related to performing essential work. I've increased expenses directly related to health impacts of COVID-19. I have childcare responsibilities or responsibilities to care for an elderly, disabled, or sick family member. I have increased costs for childcare or attending to an elderly, I apologize, increased. Oh, okay. Number 4, childcare responsibilities. Number 5, increased costs. I think I just read it twice. I apologize. Other circumstances related to the COVID-19 pandemic that have reduced my income or increased my expenses. Any public assistance, including unemployment insurance, pandemic insurance, state disability, I have received since the start of the COVID-19 pandemic does not fully make up for my loss and or increased expenses. I state this under penalty of perjury under the laws of the state of California that the foregoing is true. So that is a declaration. That is a declaration. And I've given you 6 options, but really there could be many more, but this is just an example. Remember, your 3-day notice is now 15-day notice. If you've given a 3-day notice to a tenant, you must reserve and give a 15-day notice. How are we doing on time? Are we doing okay?
We have about 17 minutes left.
Okay. So AB 3088, I'm not going to talk about too much about just cause, but there are things called just cause evictions. There was a law passed that started this year. It's called AB 1482, and it actually has a huge impact for landlords, but the exceptions are for properties over 15 years old. That's an exception. It has a huge impact. California is slowly going to where governments can be able to control, kind of like Los Angeles and San Francisco, where they can be able to control how much you rent it for, things of that nature. I do recommend that landlords read up on AB 1482 because the law still applies. And in fact, AB 3088 does bleed over into AB 1482 for just cause. So definitely, I know for most people, they're not really understanding what I'm saying, but if you represent landlords and you're an attorney or you are a landlord, you better read AB 1482, all right? Now, this is very interesting. What about for people that owe money from March to January? You said I cannot evict them. based upon a COVID-related reason on a declaration. True. So what do? You can then file it in small claims court. Small claims court typically it's between $7,500 to $10,000, depending on which defendant that you can be able to sue for that amount. It expands the small claims court to allow to receive these type of cases, but you cannot file your case for a COVID-related debt March 1st, 2021. All right, so you can't say, okay, you know what, I can't evict you because you gave me a declaration, but I'm going to sue you right away for breach of contract. Not allowed. Needs to then go to the March 1st small claims court. Oops. Okay. This is a little bit confusing because there are about 40 to 50 cities that have their local eviction laws that are currently in place. So previously, before AB 3088, the law was this. Governor Newsom said, I will give all of the counties the right to control how evictions are going to occur. So LA County was the big county that came out and said, hey, we need to do a lot for our tenants, both residential and commercial. But if a city has its own law, then we're going to defer to that city's law. Then AB 3088 came out and it says, although there is local moratoriums in place, if it's set to expire before January 31st, we're going to allow it to stay in, but it can't be extended or renewed after February 1st. The reason why that's a little bit confusing is most attorneys are, not every local moratorium gives more protections for tenants. There are some cities where the local moratorium has a shorter window to pay back. The question then becomes, which one controls? I don't have an answer for you, but I can only be able to say with certainty that AB 3088 says that if there's a local moratorium that is set to expire before January 31st, we're going to allow it to stay in. So that's AB 3088. Okay, a couple more slides. There are some additional penalties if you decide to go as a landlord hog wild on your tenants and do things that are really illegal, like lockouts. Typically, pre-COVID, it's $100 a day along with actual damages, but now there's a new penalty of $1,000 to $2,500 if the resident has provided the landlord a declaration and you continue to harass your tenants, and it sunsets on February 1st, 2021. So let's bring it together on AB 3088 only. Although, don't forget about Trump and don't forget about the local moratorium that we talked about. The state law separates current rent that's owed into two periods. The first period is the protected time period. The second period, some cities have called the transition time period. The protected period is from March 1st to August 31st. Your landlord can now give you a notice to pay rent or quit. However, if within 15 days you sign and return the declaration of COVID-19 related financial distress that your landlord must provide to you in your eviction notice, you cannot be evicted for non-payment of this rent, even if you, this is very important. The transition period is a little bit different. The transition period is from September 1st to January 31st. Your landlord can now give you a notice to pay rent or quit for each month during the period for which you don't pay rent. However, if you sign the 15-day notice and return the declaration of COVID-19 related distress that your landlord must provide to you in their eviction notice for non-payment of rent and pay 25% of the amount that's owed by January 31st, you cannot be evicted for non-payment of this rent. These are other documents that I use just to prepare for today's lecture. If you're interested, not really that important, but some people are very, very interested in kind of different orders that have come down. Here are some questions that some of the clients of KCAL have asked me, and I thought were very relevant. If I have a COVID-related event, I'm a tenant, what should you do? Just tell your landlord immediately. Give them that declaration. Don't even wait for this 15-day notice to come down. Just send over the notice right away. Will evictions eventually proceed? Yes, but they're going to be really slow. In fact, I would recommend to landlords, if you can resolve the matter of owed rent informally right away, that's allowed. And I would recommend that you do it. People can still contract around AB 3088. People can still make a payment plan. In fact, I'd recommend you do it right away. And people still ask me the same question all the time, even when I've given this lecture. Can I turn off water or change the locks? No, no, no. All right. So with that being said, we're going to go over to some of the questions that were that we currently have. So who's going to help me with the questions?
I will.
Anybody? Okay.
All right. So the first question, I think you've covered a couple of times, so we can briefly summarize, is can you evict tenants right now?
So the answer is it depends on whether it's a commercial or residential tenancy. What ended up happening is that in LA County, so courts in general are open for business. Not fully open, but they are open for business. Right now, we're going to focus on LA County because that has all of these new laws, and LA County is really trying to protect a lot of the tenants. If you're a commercial tenant, you have until September 30th. After September 30th, then you got to start paying rent. That's just the way it is. If you don't, they're going to start going after you. The courts are going to accept it because the court has essentially said, originally the court had a moratorium, said we're not going to take any of these tenant cases, but then they retracted and said, you know what? We are going to take tenant cases, both commercial, residential. State of California legislature, you got to figure out this problem. The court system, we're not the ones to figure out your problem. So the answer is you can begin evicting tenants as of September 30th, right? As of September 30th, you're LA County for commercial. Residential is now all around the state of California, all around the state of California. In your mind, you got to say to yourself, all right, it's February 1st. That's when I get to evict tenants based upon non-payment of rent. However, if you were part of my lecture earlier about pre-COVID, what did I say? Although this lecture is based upon non-payment of rent, you can be able to evict based upon other breaches of the lease. So many tenants, what they do, they don't pay rent and then they just go crazy. They like begin to rent it out. You know, they begin to sublease. They throw trash all around. They begin to yell at people. Those are breaches of the lease agreement, not related to rent. That's the reason why it was important for you to be on time today, because you can be able to evict people based upon non-payment of rent issues legally. AB 3088 is focused upon payment of rent issues only. Okay, what's the next question?
Can we request that tenants show us proof of their layoff?
That is a very difficult question, and I would recommend that you do not do that. And the reason why I didn't address that issue is I basically read conflicting laws on it. One of the laws with LA County, it depended on, well, one I read in Pasadena, one I read for LA County, is that you can require proof. And then there was another one that said you cannot require proof. And then there was another law that I read that didn't have it, it didn't address it at all. If you are going to require proof, I do not request that you do it for residential. I will have updated I will have updated information once the government body puts out more explanations on the law. I do not recommend it for residential. I believe that for commercial, you are going to be okay on commercial if you request that. But as of today's date is September 10th, I do not recommend that you ask for proof for a residential tenant. Can he repeat himself? Okay, basically you want my opinion. My opinion is, based upon the current analysis as of September 10th, is that I do not recommend for residential that you request information. The declaration is enough. For commercial, if you are intending to do it, commercial, I think it is okay to do it, but I would be cautious about doing it. And I would recommend that you speak to your attorney about it. Residential, again, is that I do not recommend you do it because the declaration is under penalty of perjury. Okay, what's the next question? Were you able to, Yao, were you able to, okay, great, all right, okay. So what's the next question?
So if the tenant stopped paying rent before the pandemic, before March, can we still evict now, or is there still a moratorium?
So that's in my opinion, if you're going after the tenant over unpaid rent and you only ask for the rent prior to the time of COVID, I believe that allows you to evict. I know it's very controversial what I'm saying, but AB 3088 plus all the COVID laws, okay, just think about all the COVID laws, March, right? Started around March 8th. That's when all the COVID laws began to start for tenants. A tenant owes you money in January. Are they able to get COVID protection? The answer, in my opinion, is no. Of course, they're not able to obtain COVID protection. You're trying to get payment previous to COVID. However, the reason why it's controversial is because most landlords are saying, many attorneys are saying, well, wait a minute, you're also trying to evict them based upon a COVID period, and therefore both of them apply. Unfortunately, the court system really, in terms of evictions, has been pretty shut down during COVID. So I have not been able to see any new cases where the judge says, you know what, that was pre-COVID. I do want to tell you, pre-COVID, judges in general are landlord friendly. So it would not surprise me if a judge would say that's a pre-COVID issue. Therefore, eviction is proper. Okay, next slide. Next question.
The lease has already expired or it's moved to month, but the tenant refuses to pay or to move out. Is there anything I can do?
So the question is, the tenant isn't being cooperative. And unfortunately, on AB 3088, that's just the way it's going to be. You're going to have many uncooperative tenants. However, most uncooperative tenants will not comply with AB 3088 declaration requirements. There just aren't. They're going to ignore you. You're going to serve them the 15-day notice. They're going to ignore that. And in my opinion, without that declaration, you're able to legally evict. Okay, next question.
Live chat. I got a judgment
Oh.
against my tenant, and finally he moved out, but he owes me rent. How do I get the money back, especially when I don't know where he moved to?
Well, the problem with that is there are debtor collection firms that are out there. The reason why I don't recommend, unless it's a massive debt, typically these debts are between $10 to $15, $20,000. I don't recommend you hiring an attorney on it just because they would charge you a lot of money just for not that much of debt, respectfully. Unless it's hundreds of thousands of dollars, it's worth it. But the debt collection companies, what they do is they'll basically chase down the debt for you. They'll take a contingency between 25% up to 75%. Some debt collection companies will pay you outright. a few $100s just to take that debt away from you. But this is where, unless the amount is significant, I don't recommend you hiring a law firm to do it unless it's on a contingency basis.
Paul, are you okay with us asking a few more questions and going a little bit over?
Yeah, of course.
So does the declaration have to be in writing?
Oh, yeah, that's a very good question. I just assume that it would be in writing. I assume that because it's under declaration penalty of perjury, you have to sign it. And so I think the question relates to, can I just send an email, or somebody sends an email in regards to the declaration? I don't think that's in compliance with the code. I'll read it again and see, but a declaration under penalty of perjury, when it's in, regular lawsuits in general, it can't be by email. It actually has to be signed. And it's not even a digital signature. It needs to be signed by the person attesting to it. So in my opinion, as of right now, and again, if things change, I'll give you the info and we could be able to put it for everybody to read. But I don't think sending an email back to the landlord is good enough. I don't know if you're a tenant or a landlord that's asking me this question, but if you're a tenant, you're trying to comply with the 15 days, I would definitely say, you can type it out, but on the bottom, when you sign under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct, you definitely need to sign that. It's just my opinion, but I'm pretty sure I'm right.
And then we have another question. If the tenant doesn't
Sure.
pay 5% of the rent starting in September, can they be evicted? On the eviction notice, should I include all of the unpaid rent before September? I know you covered this in your presentation, but I think there's some confusion around it.
Okay. So from March until January 31st, it's 15-day notice. No more 3-day notice. Okay. Earlier, we learned about 3-day notice because if you don't understand 3-day notice, you have no idea what the 15-day notice is about. So you're going to give a 15-day notice to the tenant. If the tenant owes money from March to September, you don't get to evict them, period. Okay. What you need to do is on March 1st, 2021, you need to sue them in small claims court. For any amounts that are owed between September 1st and January 31st, they have until January 31st, 2021 to pay you 25% of the rent that is owed. And they must give you also a declaration as well. One thing that I think I did not address very well, and I apologize for that, is what about the 75% that's owed? What do you do then? You do the same thing. You must go to small claims court and you must sue them in small claims court. And small claims court will open up its arms for you to sue the tenant on March 1st, 2021. And I apologize if I was not clear on the 75%, because it just hit me. And thank you for that question, because I think a lot of people had that question.
So this is for a commercial rental contract. They're saying that the 2 years expired already on July 31st. Can we as a landlord raise the rent? And can the landlord charge double the rent according to the expired 2-year holdover charge?
Okay, so commercial leases are very different from residential leases. Commercial leases are based upon contract. Typically holdover clauses in commercial contracts are allowed unless you have local rent control over commercial properties. Very rare. Most commercial tenants, they have a very big problem. They do not hire attorneys to read their commercial. They get into agreements thinking that all tenants. It does, but it really only protects residential tenants. What California courts and the California legislature have said is that if you are a commercial tenant, then you must be a sophisticated individual, and we're not going to protect you. So you can't say, oh, I speak, Chinese, and therefore the agreement was in English, and they forced me to sign it, and now there's a holdover clause. It's so unfair. Residential, that's a great argument. Commercial, that's not going to fly. So did I answer the question, or did I just get emotional and not, or sarcastic and just not answer it? What was your question again?
I've already closed it out, but it was regarding if the contract, the contract for a commercial property expired in July.
Okay.
Is the landlord able to double the rent now because they're essentially a new contract that's getting executed? But I think you covered it. Also, there were questions regarding whether or not you could share a sample of the 3-day notice, but this was pre-COVID. So is there
Okay, so your voice.
Hi, Paul, can you hear me? The question was regarding whether or not you have a sample of a 3-day notice, the pre-COVID 3-day notice that you could share. I think we just lost Paul's.
You know what? I got disconnected. Now I'm on.
Okay, Paul. The question was regarding whether or not you have a copy of the 3-day notice, the pre-COVID sample.
I cannot, there's a lot of interference on the line, so you got cut off. You want to type it to me, or?
No problem.
So as you're typing to me the question, I want to talk about the previous question. The previous question was about that there was a lease on a commercial property and you are a tenant. And what ended up happening, the commercial lease ended around March or April of this year. And the commercial lease stated that if you stay on the property, they get to charge you.
Oh no, I think we have Paul disconnected again, but fear not, if anyone has any additional questions for Paul, we'll make sure to get those answered. So the email address to write any questions to would be marketing@kcal.net. I'll type it also in the chat for everyone. Hopefully everyone got that. So Paul, I'm not sure if you're able to hear me right now, but thank you for all of that information. It was very helpful. And thank you everyone for attending. We hoped everyone learned something from this webinar that they could use going forward. We will be having more English webinars in the future, the next one being on September 24th with Paul Cheng as well. That webinar's topic will be on the pandemic's impact on employment law. Please follow our social media to stay up to date on industry news and on our KCAL hosted webinars. Also wanted to mention that we will be having the replay available. We sent out an email regarding this Zoom event. And so in that same email is also the replay link, and the PowerPoint information can also be sent if you request it to marketing@kcal.net. Super excited that we got to have the session today, and I will get back to moving my apartment right now. Oh, looks like Paul's back. Paul, just wanted to thank you so much for being on today's webinar and giving us so much useful information. It's been super helpful. Wanted to give everyone Paul's information as well. So he posted it in the chat box. That's Paul's number. Feel free to reach out to him if you have any further questions as well. Paul, do you have any statements? I'm not sure if the audio is working right now.
Yeah, no, just wanted to, thank everybody, thank you for your patience. I know that things have been very difficult for both a lot of landlords and a lot of tenants, but we're all in this together. Just, be neighborly and good to each other. As difficult as times are, I've seen a lot of things that are very negative, but I do want to say that, be that bright light that you want other people to be. So, and thank you for those that are currently doing it on a day-to-day basis. So thank you very much for today. And if there are any questions, I may need to go back to the PowerPoint because I did see a couple typos, but if you guys are okay with typos, and we'll have the PowerPoint ready for everybody. And I'll definitely look at that question that was addressed earlier. So thank you very much.
Thank you so much, Paul, and thank you all for participating today. We'll see you at the next event.
Bye.